Bismillah Rahman Rahim. Thank you everyone for being here with us today. Let me welcome you all on behalf of our director, Mr. Akmal, who it appears has some problem with his IT, which is a hazard we have on a day-to-day basis. But it seems to catch you at the wrong time, as they say in Murphy's Law. Anyway, welcome to you all, our distinguished guests who are listening to us first, and then our panel, with a learned panel, who I'm very proud to have with us today. Today, we are going to talk about an industry which contributes 10% of our GDP, 80% of our foreign exchange earning, employs over 3 million women. It's 6.5% of the global output of garments. It is easily the most important external sector of our country. What else? It's now considered a global leader in green industry. 6 out of the 10 top LEED certification institutions are in Bangladesh, and over 100 factories have top LEED certification in environmental area. In safety, almost all the factories have been certified by internationally accepted audits as safe for workers. It is a frontrunner in women's empowerment. I can easily say that we are proud of our industry, and the banking industry also grew with it. And together, they did something unique in this country. They invented what we call the back-to-back LC. Together, they did it to cater to the market, because at that time, financing the industry, they didn't have the financial capacity, the new entrepreneurs, and to finance their very large stock holdings which they need. So it was a unique product where the buyer, the seller, the bankers got together and gave something unique and new to the global product inventory, I'd say. I don't know whether it has been accepted in other countries, but certainly it did help to establish the industry in this country. But as exports grew, the buyers moved out of the LC regime, showing cost constraints, into open contracts. What the buyers gained was a loss for our RMG industry. They moved out of a structured global standards protected method for both the buyer and the seller to an open contract basis, which didn't have those protections. It was very weakly structured with little or no protection to substitute for the risks that the LC coverage gave. Even risk mitigation was not considered. The bankers who took the risks by financing the capex, inventory, and receivables based on these transactions were caught in the middle. This appears to be going well so long until the pandemic happened. Many buyers walked away from the contracts, leaving the sellers, and notably the bankers, high and dry. The pandemic exposed the soft underbelly of the entire trade financing structure. Obviously, we now know a little more, and I'm sure each stakeholder group has a different point of view. But I'm also sure their interests will converge where our national interests also are there. And that is to protect this industry, protect the jobs, protect our foreign exchange earning, and most importantly, our economy. To hear about all this, we have assembled today a very diverse but a stellar cast of participants from the RMG industry, from the banks, a top bank economist, some top legal minds, and an international development banker of repute. Let me first tell you who they are. We have Mr. Asif Ibrahim, a former president of Dhaka Chamber and a chairman of Chittagong Stock Exchange. Mr. Faisal Samad, senior vice president of BGMEA. Mr. Sohail Hussain, MD and CEO of Meghna Bank. Mr. Tariq Afzal, president and MD of AB Bank. Barrister Muhammad Manzoor Rabbi of Rahman Rabbi Legal Chambers. Barrister Rashna Imam, managing partner Akhtar Imam, and Associates. Dr. Masroor Riaz, Chairman of Policy Exchange of Bangladesh and former senior economist of World Bank. I must mention he just came back from his last job in Singapore, and I'm delighted to have him here. And finally, our international guest speaker, Barrister Ho Meng Hee, Director of Alternative Dispute Resolution at the Financial Industry Dispute Resolution Center in Singapore. Before we move on to the speakers, some administrative matters, I request each of you to speak for 5 minutes. Please restrict yourselves to 5 minutes so that we have some time for our audience, who I'm sure would like to participate and ask a few questions of the distinguished panel over here. I'm sure they don't have the opportunity to have so many of you together. And finally, we have a few words from our chairman, Mr. Mahbub Rahman. And now let's get down to business. The first speaker, and our first speaker is Mr. Asif Ibrahim. And let me tell you, I'm delighted to have Mr. Ibrahim over here. Asif Ibrahim, as I mentioned, is a director of Bangladesh Garment Manufacturers Association, but more importantly, he's the chairman of Chittagong Stock Exchange. He was a president of Dhaka Chamber of Commerce, and he's a member of the UN ESCAP, Sustainable Business Network, as a former, and he served as a board member of the Federation of Bangladesh Chamber of Commerce and Industry. So you see, he is a man with a lot of experience in the industry and has managed the carbon industry himself. So I think he's just the person to actually tell us a little more and the perspective of the industry on this very important issue that confronts the industry and of course the country. Mr. Asif Ibrahim, can you please, we can have you.
Thank you, Rumi Bhai. Can you hear me loud and clear?
Absolutely. Go ahead, please.
Thank you very much. A very good morning. Assalamu alaikum to all of you, distinguished participants in today's webinar organized by BIAC to discuss the issue of ADR in the RMG industry. I have my senior vice president with me of BGMA, Mr. Faisal, who would elaborate in detail the process. But as you have mentioned, Rumi Bhai, at the beginning, at the outset of your introduction, that the RMG industry, in fact, took off in early 80s because of, you mentioned the issue of back-to-back letter of credit. Let us not also forget that another policy also played a critical role. That was the bonded warehouse facility that was given to the exporters. So basically these two policies that the government had undertaken at that time really helped the industry grow, because first of all, it didn't, it allowed the entrepreneurs in the early days of the sector to be able to set up an industry with a relatively small amount of capital. And most importantly, the working capital that was required to finance the raw materials for facilitating that export. And you have to remember that in those days, nothing was made in Bangladesh. We had to even import perhaps a pin that we have to stick in a shirt in the packing section. So I'm just giving an example that those days it was just the machine and it was just the worker. All the raw materials used to be brought in from Japan, from Korea, from China, from Malaysia, from Thailand. We didn't have cartoons or anything else. So back-to-back LC gave us that facility. And those days in the beginning, the banks, the first generation banks, were actually the leading institutions that had taken part in facilitating the growth of the business. The renowned banks like IFIC Bank, AB Bank, those were the first generation banks those days. And some of the state-owned banks also took part. Islami Bank played a very critical role in the development of the sector by assisting the exporters, first of all, in facilitating and giving a line of back-to-back letter of credit, number one. Number two, also at the same time, giving them a local BDT facility for overdraft. And also in certain cases, those days, the export cash credit was not there. It came in much later. And so the factories were able to gradually start expanding. The non-contingent fund that was given through the facility of back-to-back letter of credit, the banks also, of course, those days I remember, if Faisal would correct me if I'm wrong, two particular areas were the sources of income for the banks as well from this industry. One was your back-to-back commission, the other was the acceptance commission. In two places the banks used to charge us. I remember it used to be 2%, now it has come down quite significantly. I think together both constitute about 0.30%, or from 30 to 0.50%. Now, coming back to the issue of alternate dispute resolution, the fact of the matter is that initial days we used to work under a guaranteed letter of credit given by the buyers through the buyer's bank to our bank, and in case there was no corresponding bank in between, we had the entire process had to go through a corresponding bank as well. And and in the letters of credit, there was not particularly any clear in the early days, not very clear indication about how to settle in case of disputes in the letter of credit. Most of it mentioned the ICC clauses, which is standard for every letter of credit that I guess is constituted by any bank. Apart from that, really nothing much was given. But then later on, when as the business started to grow, we could see that when disputes arose, particularly from the perspective of quality of the product, or say late shipment, or in certain cases the industry is as such that sometimes there are also, not all buyers are also made in heaven. Some of them are unscrupulous and they try to take advantage by asking for commissions which are unrealistic, by asking for air freights for issues which actually is not the supplier's fault. Sometimes when they see that the sales are bad, they try to put pressure on the buyer. So the mechanism for settling these disputes was not very clear in terms of where we would go, how we would approach. And later on, we saw that when the issues of ADR started to come in, they, I think, preferred alternate dispute resolution centers in their own country, where they are based, or from which the issuing country of the bank was from which bank the LC came in. So that is where even today, as of today, we do not have a proper structure like that, where ADR is enforced in the contract. Nowadays, a lot of letter of credit has been replaced by what we call based on a contractual basis. The back-to-back letter of credit is open based on contracts instead of LCs, because LCs also come with charges, and we are all trying to cut down costs, and hence LCs on the way of being phased out as well. So that is the real scenario right now. And in terms of also bargaining capacity, the suppliers are always at the other end of the, if you take the justice, justice, it's like this, we are here and we are there. So that's something that we have to address as well. So basically, I think we can today in the discussion, we can have an open session where I think we can brainstorm and see realistically what is really possible in terms of to get ADR popularized in the RMG sector. I'm sure Faisal would certainly supplement me and also add a lot more to what I have said. Thank you very much, really.
Thank you very much, Mr. Ibrahim. I think you hit on a very important point of power imbalance. I think power imbalance often causes the one party to suffer in a way, and it always becomes what we call a zero-sum game in a dispute situation. So I think that is precisely why there are some quarters who want this to be addressed through ADR, because ADR is not a zero-sum game. So you can have a discussion, you can have a negotiation. Anyway, that is for our speakers to speak at more length, and I'll be now delighted and honored to invite Mr. Sohail R.K. Hussain, Managing Director and CEO of Meghna Bank. Sohail Hussain has been in the banking industry for 30 years, and he has experience in corporate, SME, green retail, and infrastructure financing. He has served Citibank as an MD and CEO, and also served Eastern Bank and Standard Chartered Grindless Bank, and earlier just Grindless Bank. Mr. Hussain was a vice chairman of Association of Bankers of Bangladesh, and also has been on the board of directors of Citibank Capital Resources, City Brokerage Limited, IIDFC. So with all that experience in banking, we'll get a new perspective now, having heard from the side of the industry. Sohail, Mr. Hussain, please, can we have your deliberation?
Thank you, Mr. Mohammad Ali. Mr. Mahbub Rahman, Chairman BIAC, Mr. Rumi Ali, CEO of BIAC and Chairman AB Bank, fellow speakers, the viewers who are watching this, good morning to you all. Thank you for the opportunity to say a few words on risk management during COVID-19 and how ADR can protect banks and the RFG sector. If I can start with a little bit on the banks and the challenges they face in pre-COVID and post-COVID crisis. COVID-19 has undoubtedly had an unrivaled and unprecedented impact on the global population and economy. Bangladesh is obviously no different and is suffering from both domestic challenges as well as challenges arising from the impact on global supply chains and markets. These challenges are immense. Banks, or the financial system, is the heart of any economy. The banking system in Bangladesh was already suffering from a very high non-performing loan portfolio problem even before the spread of the coronavirus. The industry had approximately 11.5% ratio, NPL ratio, and about approximately 93,000 crores by the end of December 2019. Beyond this, there's also a marginal portfolio of rescheduled loans where repayment history has been unsatisfactory. The NPL portfolio is eroding capital, incurring higher charges for international trade facilitation, impacting on the sector's return on capital, high lending rates, and so on. A deepening crisis in the financial system may impact on the country's rating. Bangladesh Bank, various related bodies of the government, the Association of Bankers, and other stakeholders have been trying to find a solution to this with, frankly, limited success. And then we had the COVID-19 pandemic, which will undoubtedly put further pressure on the already weakened banking system, the overall economy, and of course, the livelihood of the population and their health. The government has set up an elaborate and effective scheme of stimulus packages. Banks are taking on a large burden of the responsibility of funding and distributing the various stimulus packages. On top of this, banks have to assess, develop effective strategies to manage the increased operational and credit risk from its traditional activities. One of those strategies should be to incorporate alternate dispute resolution in most or all of their contractual obligations. ADR has been in place in Bangladesh for some time. The Authorin Adalat Ain allows ADR, i.e. mediation. It's built into the legal framework. However, court-directed mediation has not been effective, as by the time mediation starts, both the parties have already assumed adversarial litigation positions. Banks have traditionally relied on litigation as the primary way of dealing with disputes or defaults in their loan portfolio. Litigation is an adversarial process, which takes considerable time and expense and rarely allows the banks to recoup their losses. Furthermore, through a combination of writs, missed hearings, a huge backlog has appeared in the court system. In June 2019, there were almost 63,000 pending cases with the author in court with a value of 117,000 crores. The economic cost of this is huge. COVID-19 has created fresh challenges for Bangladesh's legal system and the banks. Concerns with physical presence, overt reliance on manual and paper-oriented systems, lack of familiarity with video sessions, lack of infrastructure are creating further delays in using litigation as the only recourse to defaults. In spite of the commendable stimulus package for coronavirus impacted industry, there is little doubt that non-performing loans in the next few years will go higher. ADR can be a solution to not only relieve the pressure on the court system, but also can be a cheaper as well as a quicker remedy to the problems of the default industry in the banking sector. This is also related to the RMG sector. As you know, we finance customers, and the risk profile of the customers becomes the risk profile of the banks as well. So ADR has the added benefit of treating loan obligors as a going concern through amicable settlements before going for liquidation. Litigation assumes that litigation is the only recourse. So ADR can be a win-win for both sides. We've also seen a trend in borrower defaulters who migrates and settles abroad by laundering money abroad. Bangladesh, as you know, is a signatory to the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards 1958, which means an arbitration award can be enforced in any of the 159 signatory countries. I can tell you from personal experience that I have in the past and also currently I'm dealing with defaulter borrower situations where the defaulter has settled in Canada, United Kingdom, and so on, and they have diverted the bank's money abroad. Therefore, incorporating arbitration clauses in loan sanction advices can strengthen the bank's risk portfolio, can strengthen the bank's ability to recover money both locally as well as abroad.
Okay, so I think you brought out a very important point over there regarding our banking industry, in the sense that people often take loans and go and settle elsewhere, and that creates a huge in enforcing or recovery of loans, because you cannot actually take your case to a different jurisdiction because jurisdiction in Bangladesh, so they go out of reach. So I think that's a very important point which we have to keep in mind. So I think it's now I'd like to move on to the next speaker. And our next speaker is Mr. Faisal Samad. He's a Senior Vice President of BGMEA, that's the Bangladesh Garment Manufacturers and Exporters Association. And is the Managing Director of Savatex Group, comprising of knit vertical integrated industry from fabric production to garments, socks, manufacturing facility, designing and printing unit. Mr. Samad studied at the Business and Managerial Economics in the Stony Brook University of USA. Mr. Samad, can you please, the floor is yours. Thank you.
Thank you. Honorable Chairman BIAC, I'm assuming Mr. Mahbub Rahman is here, I would assume. If not, salam to him. Distinguished panel of today's webinar, and of course our vast experienced moderator, Mohammad Rumi Ali, and all our guests who joined us, Assalamu alaikum, and almost a very good afternoon. It's 11:59. Before actually I kind of, give our position from the BGMEA, I would like to clarify one thing before I start, and this is my query to the moderator. Is today's discussion about the the default culture of the industry, or are we talking about the industry and the overall status? Because from what I heard from Mr. Sohail Hussain earlier, I mean, his focus was more about authority in Adalot and and the ADR and the relation. And I mean, I was, because I read the concept note and I didn't see that that was part of the agenda. So if it is, then that'll be one direction. And if it's going to be focused on the industry and where we are and where we're going to be proceeding, then it's going to be another discussion. So could you please clarify?
Let me come in over here, Faisal. The discussion was intended for specifically the garment industry, and particularly what happened to the industry after the pandemic, when you had a lot of the foreign buyers walk away from your contracts. And it appeared to us, the observers, that you had nothing to, you didn't have anything to react to that except, appeal to their good sense. And you appeal to ILO and other places. I'm talking about BGME over here. So what we saw is that structurally, you didn't have, once you moved away from the structure of a letter of credit, which was very globally recognized way of doing business, to the contract structure, you didn't protect yourself sufficiently. That was our impression. But as I said, people will have different points of view, and you may have a different point of view. I think.
Add Ruben Bhai. Mr. Samad is quite correct. I sort of ran out of time before I could broach the issue of RMGs. Okay, so I apologize for that.
I'm sorry. Respect to all
very important point, general points, which will help the discussion. I think it's important.
Absolutely.
But Faisal, yes, I would like the discussion to be more restricted to what this thing we talked about, which is basically about the RMG industry, because that is the most important industry.
Absolutely, absolutely. Thank you very much for the clarification, Mr. Hussain. You as well. Thank you very much. It was because, you see, the problem is, and this is something that our board and when Dr. Rubana Haq took over as a president, you see, it's the perception. It's always been the perception. So you see, we're always on a back foot here. Given the contributions of the garments industry and given where we all are today as a nation, we're still on the back foot. So in Mr. Hussain's sort of deliberation, he started with the NPLs, he started with the risk profiles, and it's all fine. I'm not going to negate that. But today's conversation was of a different thing, and I would have hoped that, and when we have got distinguished panels here who are honorable bankers, yourself, Mr. Ali, as well, a very distinguished former banker, that we'd like to listen from you about us as the industry. And it's not only about the ADR, it's about what's happening to the industry, how are we affected, and what safeguards are there. We don't want to talk about the sort of the bad apples in the industry who have created this impression. They're bad apples. We know who they are, and they've been identified as well. However, let me start.
I don't think we should go down that road. I think
that is
our discussion.
I think we need to be clear on this subject, because then we know where we want to head towards. So anyhow, I'm clear, and thank you. Going back to sort of formally starting my kind of little say is, on behalf of the president of BGMEA and the board, I thank, first of all, Bangladesh International Arbitration Center, BIAC, for organizing a time-sensitive webinar on risk management and dispute resolution in reference to the RMG sector and banks. COVID-19, referred to as a global pandemic, or as I see it, a very global gray world, where the unknown has taken over ourselves, our lives personally and professionally, having both positive as well as negative impacts. Mankind, as we can see, has adapted in multiple ways to continue to seek solutions and the right roadmap for the present and the future. The RMG sector, pre-COVID, as per our estimates, had nearly 2,500 factories as members of the BGMEA. Post-COVID, now, as per yesterday's statistics, we are roughly down by about 500 factories, which have closed down due to either loss in orders, bankruptcies of customers, and just overall economic downturn. So these are very, very serious numbers if you think about it. some of the post-COVID sort of realities of you know, the negative export trend are the lowest. I mean, the negative position is the lowest recorded ever in the history in the last 30 years. And I'd like to share a few numbers here for you know, from our research and from what we have collected. I'm just going to read this out a little bit. One is that in the fiscal year 2019-2020, we ended with $27.83 billion of RMG exports compared to year-on-year at $34.13 billion. This is RMG only. The decline in exports in actual amount is USD 6.3 billion, which is around 1/5 of our exports of last year. So the loss in 3.73 billion worth of exports, which out of the 6 billion, out of the 6.3 billion, is only in this last quarter between April and June. So it's I mean, it's mind-boggling actually, to tell you the truth. With this decline and in exports and cancellations, I believe, and then our honorable bankers who are here would be able to also, I'm sure, shed some light on their statistics of the industry. But from our calculations, we're roughly at about nearly between $2 to about $2.5 billion worth of liabilities, which may incur, you know, with the back-to-back settlements. So, you know, all of the above, are, as all the figures that I've sort of said, I'm sure our bankers here who are part of this, our distinguished bankers are part of this. I'm sure it's a fearful sort of thought. I can understand it, and even for us, it's a fearful thought. But you know, to shed some positivity to these negativity is there is a positive trend. The stores, our customers, our buyers who were closed over the last 2 months, they've opened their shops. The Western world's opened, you know, over the last 2 to 3 months. Sales are picking up. Our export in July was negative 0.6% compared to compared to May and June, because and in fact knit had an 8.47 growth. Woven was down by almost 10%. But these are only numbers because our factories were closed for 2 months. We didn't know where we were going. We had no understanding of whether the customers will return. But now we see that the customers have returned. They are taking their merchandise slowly, not fully, in phases. You know, which again leads to what we were going to talk about today, about the LCs and contracts and back-to-backs. So it's working. It's slowly moving. It's going to take time. I don't think it's going to be something that, you know, everybody's going to stand up and say tomorrow we're all happy and we're progressing. There were reports in the newspapers last week, including the Daily Star, where they mentioned that Bangladesh's garments is back in position. No, it's not back in position. We're progressing towards to be back in position. It will take us some time. This is where all of us together can progress in the right direction if the right policies are in place. The Honorable Prime Minister, she was very kind to hear of our issues and to support us to survive, to fight and survive. What could the banks do? You know, as Mr. Hussain said, he's right. There are NPLs, there are defaulters pre-COVID, post-COVID. But, you know, I mean, of course, accepting those bad apples, everybody's trying to survive. So these policy supports by the government has been crucial. But of course, with these policy supports, also requires the proper implementation of these policy supports. So that we need to work through. And I know the banks are kind of confused at times when I have to call for some members who deal with banks who don't understand the circulars of the Bangladesh Bank. Sometimes it's confusing. It's understandable because the Bangladesh Bank has issued I think 8 circulars in the last 4 months. and there are multiple, understandings of it. So anyhow, I want to sort of move on with appreciating all of us who are in this, including the bankers, and how we're all trying to work and come out of this. So going back to the legal side of things, I think personally, on behalf of the BGM, and Asif Bhai is also on the board with us, I think that these disputes has been happening for decades now. I exchanged this with the bankers here, that when we had these issues, when our buyers didn't pay us, when the goods were shipped to the importing countries and were released by the forwarders, and we as exporters, in good faith, we exported. The goods went there, the customer cleared it, they didn't pay us, they took the goods. We weren't protected up until 10 years ago when BGMEA incorporated the CNF Act, where now the forwarder cannot hand over the goods unless until they get an NOC from us as the supplier, that whether they can hand over or not. So there are protections. There has not been, and there will be. And our esteemed barristers and legal minds who are part of this, I'm sure they can help us further along this way. So the LC was a classic mode of business, and all banks preferred it. Contracts came into play, and we are all working with it. BGMEA in the year 2003 formed what is called an arbitration committee. We saw that all these cases that were happening, that we need to resolve. Where will we go? Yes, you're correct. Any courts in this country will either take time, or it doesn't give us the right solutions. So we needed to put the problem makers and the problem sort of persons or the companies who are faced with the challenges to come under some sort of a framework. So BGME established the arbitration cell in 2003. In the last 2 years alone, we have settled 153 cases mutually, resulting in almost $5.9 million of value to this settlement, which could go either way. I'm not saying it always went in favor of a manufacturer. It could be in the supply chain that a supplier of the RMG industry did not get paid. That company brought the case to the BGMEA, and the arbitration committee reviewed it, brought the two parties together and settled it. However, these require certain legal sort of frameworks, and again, I'm sure the BIAC can help us in these areas. We can talk with Mr. Ali. I have briefly spoken. Again, all of this is to facilitate our businesses, and as long as we understand that it's to facilitate it and to be put a positive sort of positioning, I'm sure that we can progress in a right direction for the industry, for our country, and overall it'll be a win-win for all. My last 2 points that I will conclude with, and it's a request to the legal minds here, and also to our honorable bankers here as well, is in Bangladesh, as an industry, and as a company, as an entity, we have no exit policy. There's no exit policy in this country. So if you want to exit, you can't exit. How can that be? You have big retailers like Sears, JCPenney, TJ Maxx. They've all filed Chapter 11 or Chapter 7, and they're exiting out of their commitments. Primark, one of the biggest buyers in the world today, they were going to exit. Then BGME put the pressure on them, so they said, no, okay, fine. You know what? We will honor, which not all buyers did. So you see, we need also an exit policy. If somebody cannot survive, if they're out, they cannot. Why can we not exit? So I know there is an exit policy, and the honorable and our BGME president, we have been working on this, but we need your help also to formulate a right exit policy. So it's passed in the parliament, and that the right people can exit, not somebody who's defaulted or taken the money or something else, but for the right reasons, we should be able to exit if we want. That's one.
Can I request you to finish in the next 30 seconds?
And the last point is the bankruptcy laws. to enact them in some form or manner. That's all, and thank you for your patient hearing. I'm sorry if I offended anybody, but I wanted to be direct, and I wanted to sort of put it out there because that's the whole point of this conversation, to come out with something, a win-win. Thank you.
Thank you, Mr. Samad. I think your points are well taken. You have given a sort of a history of what happened and come to the present situation where you had the recent problems with your buyers. And I was very happy to learn that you have embraced arbitration. The issue is, of course, whether these clauses are included in your contracts. And I don't think it's uniformly followed, including these in your contracts. Anyway, I think we had some very important issues raised by you. And yes, you have stated your opinion frankly, and thank you for that, because I think that's exactly what we need to hear. And now I'd like to pass to our next speaker, Mr. Tariq Afzal, President MD of AB Bank Limited. He is again a distinguished banker who has been with, before he joined before he joined AB, he worked with Credit Union of Canada, ANZ Grinders Bank, Standard Chartered Bank. He was also in Bank Al-Falah, BRAC Bank, and served as the CEO of Dun & Bradstreet rating agency in Bangladesh. He is an MBA in Finance and Marketing from Victoria University, Melbourne, Australia, and BBA Marketing from Middlesex University, London. Mr. Afzal, the floor is yours. Thank you.
Honorable Chairman, BIAC, and today's moderator, Mr. Rumi Ali, former Deputy Governor of Bangladesh Bank, and my learned friend from Meghna Bank, my colleagues, and learned speakers of today's session. Thank you for inviting me. Thank you for arranging this session, BIAC. Now, in a tripartite scenario, I was giving a very patient hearing to Mr. Suhail R.K. Hossain, my friend, and Mr. Faisal Samad, Senior Vice President, BGMEA. Now, it is, I can tell you something, in a tripartite scenario, all stakeholders are involved, and all stakeholders must reconcile to progress the RMG sector, which has been the contributor to the reserves, foreign reserves of Bangladesh for many, many years and decades. Now, I'll just share some highlight between the banks and RMG scenario and the present scenario. But before that, I would like to give an opinion. All claims, disputes, controversies arising out of or in connection to a performance, interpretation, application, or enforcement of any agreement, including but not limited to breach thereof, shall be settled amicably between parties at first attempt within a stipulated time. If such amicable settlement is not achieved, the same shall be referred to a mediation through lawyers as appointed by each party. A resolution through mediation shall be achieved in a stipulated time, but failing such, either party can seek to settle through arbitration, part the Arbitration Act 2001. But the arbitration should be in Bangladesh, and in any agreement, they have the right, or it can preclude either party to finally settle through a dispute in a competent court. Now, considering that, if that is a clause embedded in any contracts, perhaps that could ease off a lot of forecasting and tensions between banks, RMGs, and their buyers as well. In a recent scenario, in the last months, since the outbreak, government and central bank have introduced stimulus packages on multiple segments to promote and ensure that RMG workers are paid, working capital are being supplied. And since April till date, we have paid grade 1 to grade 7 salaries for the RMG workers till date, I think till the month of July. However, having said that, the scenario between the entrepreneurs and the financial institution is basically a reciprocal scenario. And in that, there are some growing concerns to ensure that there are ongoing support to the RMG to ensure a smooth transition for exports on all fronts. There has to be a scenario of repayment of loans, which can become a greater concern if if that scenario is not addressed properly. Now, if we look at the RMG scenario, in many cases, RMG has been facing challenges in exporting pre-order shipments, as Mr. Faisal Samad and my friend Asif Ibrahim has stated. Also, there has been several discrepancies in the letter of credits to escape payment liability for the buyers, which will eventually contribute to defaults and may strain the corresponding relationship for the banks. Because in any LC scenario, local banks are always dependent on international counterparts. Also, for RMGs, at times the contracts are not properly negotiated with their foreign buyers. So perhaps in a scenario, as Sohail has said, that it is cost efficient, we also feel that an ADR clause can protect multiple interests. And as we all know that recently the courts have been operating virtually under the usage of information and communication technology in Court 2020 ordinance. But eventually this virtual scenario the disposal of cases will continue to grow the backlog. But as an alternative, we are also seeing that institutions like BIAC and other, the increased attention on out-of-court settlements through negotiations and mediation by lawyers are growing. Also, as the learned session are aware, that section 22 of Orthorin Adalat 2003 and part 5 of section 89A and B of Civil Procedure 1908 give scope to parties during the civil suit process to opt for mediation and arbitration. So I personally feel, and I have discussed this among in Central Bank, in Bangladesh Bank quarterly meetings, that we do found, and it was always initiated by BIAC. I remember attending a session with Bangladesh Bank and World Bank also, that a well-rounded ADR clause needs to be added in commercial contracts to ensure all possible routes for settlement. And I personally feel the tension between the exit clause that Mr. Faisal Samad has stated, all these can be mitigated through an amicable settlement and ADR and within the jurisdictions of the law of the land. Thank you. I hope I was able to entertain you with some points. Thank you so much.
Thank you, Mr. Afzal. I think you brought out some very important points, and particularly your discussion on why ADR clause can strengthen the existing contracts. I intentionally kept the lawyers in the end because we want to know from the legal minds over here whether it is really a legal problem or is it a trust issue, or how should we manage this? Or it should be, strictly in the courts of the country. So, I think that is where they can be. So let the others give their views, the industry, the bankers, and then the lawyers can come in and tell us, because I think they can really tell us, distill this discussion into the real core takeaways. So before I go to the lawyers, I have got one more speaker. That is Dr. Masroor Riaz. And finally, we have someone who is in the ADR business. So he can give us some perspective, or international speaker, so we can learn from the experiences, what's happening in other countries. So I'd like to invite now Dr. Masroor Riaz, the chairman of Policy Exchange. Masroor is an economist of huge experience in the country. His time at the World Bank as a program manager and a senior economist, he served for 10 years. And I think the focus, we saw at that time how IMF's engagement, IFC's engagement and the World Bank's engagement with the country grew almost exponentially, which I think we must give some credit to this young man who worked over there at this particular desk. I think for the first time, the World Bank recognized that this is an investable country. And what was in a few years back, a few $1 million rose up to $1 billion. So I'll be very, very interested to hear from him. He is a PhD in development economics from the University of Manchester, UK, and an MBA in finance and economics from the University of New Orleans, USA. Masroor, the floor is yours. Please let us know what you have in your mind.
Thank you, Mr. Ali. Mr. Mahmoud Rahman, Chairman, BIAC, today's moderator and session chair, Mr. Rumi Ali, CEO of BIAC, Mr. Azad,
We are not hearing properly. Can I request the... I think
So your audio is echoing.
Shall we?
Am I audible now? Is it better?
No, sir, you're still echoing.
So, Mr. Moderator, if you can move on to one next panelist, and then I can reconnect. Maybe that will help you.
Sir, you need to unmute, sir.
Unmute, right.
Yes.
Our next speaker is Barrister Rashna Imam, Managing Partner of Akhtar Imam Associates. She is her area of interest in legal practice include corporate and commercial, foreign investment, labor, employment, banking, commercial arbitration, power, insurance, anti-corruption, and bribery laws, amongst others. She had her LLB and Masters in Law from the University of Buckingham, UK, and Bachelor of Civil Laws from the University of Oxford, UK. Barrister Imam, the floor is yours, please. Thank you.
Thank you for inviting me. Am I audible?
Yes, very much so. Please go ahead.
Assalamu alaikum and a very good morning to Honorable Chairman, to the Honorable Moderator, Dr. Ali, and distinguished panelists. Just to ensure that we're all on the same page, my understanding of today's topic is that we're going to talk about the impact that ADR can have in managing risk in the banking sector as well as the R&G sector.
That's
so,
exactly. Go ahead, please.
With that in mind, with the onset of the pandemic, we essentially saw two phenomena pertaining to these two sectors. One, as the distinguished panelists before me highlighted, was that of non-performing loans. Not that that was a new phenomenon, that was already the case, that we had a very high degree of non-performing loans, but the pandemic added to that number. And the other phenomenon is that of a host of contractual disputes arising in the RMG sector. And by contractual disputes, I mean disputes arising out of contracts between exporters and buyers. Most of these, by and large, were in relation to force majeure clauses being invoked by the foreign buyers, whether that's been legally invoked. Also, we've seen price reduction demands from the foreign buyers that even if we don't cancel the contracts, we'd like you to reduce the price by, say, 50% and so, and revise the contracts accordingly. So it was arguable whether these were under duress, so on and so forth. So a host of contractual disputes. So in relation to these two phenomena, what were the options open to us so far as resolution of these disputes were concerned? With regard to the banking sector, essentially it's loan recovery that we're talking about. So in the normal course, the option open to the parties are under the Orthorin Adalat Ain 2003, which essentially is litigation. And litigation itself means that this could take anywhere, this could be extremely time consuming, extremely expensive. And at the end of the day, we cannot forget that there was a colossal backlog of cases to start with in our court systems. And this pandemic, due to this pandemic, the courts were closed for some time. I believe over a month, the courts were closed. So that only added to this backlog. So in this situation, to actually start an Ortholin Adalat Te Mamla and then go ahead with it, that would be extremely time consuming and expensive. So moving on from ADR, from litigation, what were the other options open to us? The other option is, as we have been discussing, as the topic before us today is alternative dispute resolution mechanisms. In other words, it could be mediation, arbitration, conciliation. Now, if we looked at the pros and cons and the effectiveness of the different ADRs available to us and whether these can effectively mitigate the risks posed in the banking sector, we have to look at the law that is prevalent. So far as banks are concerned, Orthorin Adalat Ain in sections 22 to 25 has provided for ADR mechanisms. In other words, once a suit is instituted, courts can actually refer the matter for mediation. However, I believe, as Mr. Hussain pointed out earlier, by that time, once a court is instituted, the parties were already in an adversarial stance against each other. So the other option open to us, other than mediation as per the Orthorin Adalat Ain, is that of arbitration. With regard to arbitration, there has to be an ADR clause in the loan agreement for us, for the parties to invoke arbitration. Even in the absence of an ADR clause, of course, the parties, if they mutually give consent, can refer a matter to arbitration after a dispute arises. But of course, having an ADR clause in a contract makes much more legal sense, because then you get to draft that ADR clause to meet the needs of the parties, to reflect the bargain that was struck between the parties. So a well-drafted ADR clause is important and should be incorporated in loan agreements if we are to invoke arbitration. Having said that, I'd like to share my experience, our firm's experience as well, in relation to arbitration. I mean, we're always talking about how effective, how much more effective arbitration is compared to litigation. But unfortunately, in a number of cases, my firm's experience has been quite the contrary, in the context of Bangladesh, of course. And I realize that there is a shortage of time, so I'll quickly go through the experiences. In one case, there was an international arbitration award being made under ICC arbitration. My client won the award and we wanted to enforce it in the courts of Dhaka. Obviously, the other side wanted to set aside that award and challenge that award. And this took 30 years from the beginning till the end. The award was made in 1986, and it is last year that the award was set aside by the appellate division. So this, by no definition, is expeditious hearing. And the system is responsible for this. By the system, I mean the prevalent practices so far as arbitration is concerned, and the inadequacies of the Arbitration Act is also partly responsible for this. I mean, this is supposed to be expeditious hearing. 30 years is not expeditious hearing. So having said that, quickly to move on to the RMG sector. Again, with regard to the RMG sector, so far as dispute resolution is concerned, the options open are either litigation under the Civil Procedure Code and Specific Relief Act, which would take 20 to 30 years while it makes its way, these cases, from the lower court all the way to the appellate division. And so it's obviously not, it's time and cost effective by any stretch of the imagination. And the other option is well-drafted arbitration clauses in the contracts between exporters and buyers in the garments industry. And again, when we speak of arbitration clauses in the agreement, unless and until we bring about reforms to the Arbitration Act and the practices prevalent in Bangladesh, this is not going to be a more effective remedy than litigation. We will be fraught with the same difficulties as litigation. And some of these reforms very quickly would be, first and foremost, to set a time limit to arbitration proceedings. Currently, under the Act, we don't have a fixed time limit that one has to complete the arbitration proceedings within a given time frame. So I strongly recommend that. And the other would be to set a time limit to application challenging awards, arbitration awards that have already been made. Again, because these go on for years and the parties don't get any relief as a result of that. A few of the other reforms that I would like to mention would be, and these may sound a bit innovative, but see, if it is a local arbitration, then setting aside or enforcement of that award starts from the lower court. Maybe we could do away with that. So that gets rid of one leg of the process. We could directly go to the High Court or directly appellate division to cut the time taken to enforce or set aside arbitration awards. So that could be a remedy. Another would be, which is very, very unfortunate, that once an arbitration award is made, the finality of the award and the whole point of arbitration is defeated if the court before which that award is challenged sort of sits as a court of appeal and reassesses everything and tries the matter again. So even though the law gives very limited grounds on which an award can be set aside, the courts, unfortunately, there is a tendency with the local courts to enter into the merits of the award, to reopen everything. And that takes at least 5 to 6 years just in the High Court, and then umpteen years in the appellate division. So this is a practice that really needs to be frowned upon and avoided if arbitration is to become a very effective and expeditious remedy as it is supposed to be. So
Okay.
severely restricting the grounds. Sorry, I believe I don't have more time.
Thank you, Barrister Rashna Imam, for your deliberations. I think you have made a very important point that arbitrations can also be as lengthy as the other forms of litigation. So I think we have got to think about it. One of the issues I would, if I'm not a lawyer, but I can suggest is the two parties agree to a rule. Whether it is, BIAC has its own rules, which if they agree can limit some of them, mitigate some of the issues you have raised, which is one of them was the length of the arbitration, where you both agree that it should be within the particular framework. So I think those things could actually help. So at this point, I think we are running out of time, if you'll forgive me. I'd like to now move on to our next speaker. Our next speaker is Barrister Manzoor Rabbi, head of Rahman Rabbi Legal. Sir, would you like to speak? Because I'm keeping everything short. I know you have a very long introduction, but I'm cutting short the introductions before I move on. Barrister Rabbi, please.
Yeah, good afternoon, and thanks to everyone. And thanks to BIAC for having me here. Regarding the risk management and regarding the application of ADR mechanism in terms of resolving disputes, I think we all are aware of the facts and figures and the problems. And as a lawyer, I want to offer some, propose some solutions. In terms of risk management, to me, most important thing is the time and cost management, because in my opinion, in ADR, especially in arbitration, the cost management and time management has become an issue. And from that perspective, the arbitration clauses that we are drafting and the arbitration clauses that we are giving effect to may have some sort of provision in terms of dispositive motions. In terms of in a straightforward matter, sometimes a scope of dispositive motion can make things easy and short. If you look at the rules or arbitration rules of the American Arbitration Association, AAA, Rule 33, they have this sort of provision. Dispositive motions are some sort of request to the tribunal for summary proceedings. Once a party filed for this sort of motions, the tribunal or the panel can avoid some procedural issues, and also they can avoid some issues that are already settled on paper, and they can stick to the issue in question and proceed. And obviously, if the parties and obviously if the tribunal invoke accept a dispositive motion and proceed accordingly, that would obviously save some time. However, in that respect, I have an opinion in terms of the Arthurin Adalat Ain 2003 that we have, and before going into that, I want to say that in these sort of situations, the parties must have a choice. Whether it be arbitration or whether it would be litigation, whether it would be long or it would be a summary process, the parties should have a choice, in my opinion. If you look at section 13, subsection 4 of the Arthurin Adalat Ain, it says that at any stage of the case, if the court feels that there is no such a dispute, the court can directly go for judgment. My problem with this sort of provision is that in some cases, the parties may be adversely affected if something like this is invoked. Because if I talk about my experience from in USA, the party choose the process, whether it be a summary process or whether it be a detailed process. And dispositive motions help the parties to pray before the tribunal to go for summary process, and at the very beginning of the arbitral process, like the first procedural hearing or the second procedural hearing, the court decides whether they want to accept it or not. And I think, and the tribunal decides, and only then they proceed upon a ruling, not at any stage of the arbitral process. And I think in terms of time management, also in terms of cost management, the scope of dispositive motions can have a very, very positive impact. And when we draft an arbitration clause, in my opinion, we can think of incorporating this sort of provisions, that any parties, whether it be RMG sector, or any stakeholder from there, or whether it be bank, they can request the other party to negotiate on the scope on application of dispositive motions. My next point is that in terms of mediation for financial issues, rather than an ad hoc mediation or an open-ended mediation, I would prefer something like a framework mediation. That framework mediation may be arranged under the auspices of an institution. Like if we look at the Labor Act 2006, there is a provision for conciliation. Conciliation is some kind of framework mediation. I have heard the Vice President of BGMEA, and many thanks to him for the information that the BGMEA has an arbitration system. In my opinion, is more like a framework mediation. So stakeholders, even BIAC can arrange something like that. So BIAC may have a panel, and if the both parties agree, they can mediate the matter under the framework of BIAC, and that will save a lot of cost. If you look at the current trend in the world, mediation is taking a good go ahead, because as Barrister Rashna Imam said, time management, time issue has become an issue in arbitral process. So framework mediation may be a good option for that. In terms of arbitration for financial issues, and also for many other issues, there is an ongoing trend in the world that arbitration under the supervision of exclusive institutions. So like in England, in UK, we saw the International Cotton Association arbitration, FOSPA arbitration, or in the USA, the FINRA arbitration. So for financial sectors, rather than an open system, we can have a exclusive institutionalized arbitral system. That will help. That will, in my opinion, that will give a lot of confidence both to the banking sector and also to the RMB sectors and other business sectors, because and BIAC can have a pivotal role in facilitating that institutionalized arbitration. I am a supporter of institutional arbitration because my opinion is that ad hoc arbitration can give you some ease, but institutionalized arbitration can give you some certainty. For that many reason, I prefer to have arbitration under the auspices of an institution, under the framework. And the CEO of BIAC, Mr. Rumeli, the moderator of the session, he has already mentioned about the rules, and it's unfortunate that we do not have an arbitration rules made under the Arbitration Act 2001. BIAC has a rule, so that rule can help you to mitigate your time, and to some extent, in my opinion, to mitigate your cost as well. Because arbitration is such a procedure, if you can manage your time, you can certainly manage some of your cost as well. And regarding the appeal process, obviously I heard by Mr. Rashna Imam She spoke about the time required before the High Court division, also before the Appellate division, and she's quite correct. And that is to some extent frustrating, but at the same time, we can think about an appeal board under the auspices of an institutionalized framework. If I talk about the dispute settlement board of WTO, WTO has a dispute settlement board, DSB, and they have a preliminary arbitral panel and then an appellate board. So there are many other arbitral institutions. They have their own appellate board, and if anyone wants to challenge the award of that appellate board, they can directly go to the appellate division.
Thank you, Mr. Barrister Rabbi. I thought that was a very useful discussion you had. I think I should inform you that BIAC does have rules for mediation, and if the two parties agree to the rules, they can cut down, as you mentioned, the time, and then it's within a framework. It would be a framework-based mediation. I sort of thought the summary hearings is a very, very good idea to cut down time in case of arbitral hearing, because if we can agree on that, then you don't need to proceed further. So, you at the outset, you sort of agree on whether to go on or not to go on. So I think that also is something we will have in our mind. We could certainly look into that to see if we can incorporate that in our rules so that this can be used in future. And I also heard what you said about the financial institution, the arbitration for financial institution, ADR, how that can be a separate institution. Right now, let me tell you, we are the only licensed institution, BIAC, and we are now suffering from, issue of sustainability because not enough cases are being referred. So, if we can somehow get people to understand that there's a need for institutional arbitration, only then, the financial arbitration will also come automatically. So I think it's a chicken and egg situation for us also. So thank you very much. Anyway, I thought that was good. I will now go, before I go, I think I should mention that Barrister Rabbi, is he specializes as an arbitration lawyer, and also has worked outside Bangladesh in USA and UK. And he is a Fulbright scholar and had LLM in international arbitration from the University of Miami School of Law, Florida, USA. So you heard from someone who knows his business very well. Thank you again, Barrister Rabbi. And now I've already introduced Masroor, Dr. Masroor Riaz, who is the chairman of Policy Exchange. Can we now hear you?
Thank you, sir. Can you hear me well? Am I audible?
Yes, you are. Thank you very much.
Okay, thank you. And I apologize for the technical glitch that came in the way last time, and thanks for bearing with me. So first of all, let me congratulate BIAC.
5 minutes. Please
Sure.
stick.
Sure. So at the outset, let me first congratulate BIAC and its leadership, particularly Chairman Mahbubur Rahman and CEO Mohammad Rumi Ali and the team for bringing BIAC through great strides to where they are today. I still remember the day we all together under the leadership of ICC with the support of the World Bank Group, we launched BIAC. I think it was 12th of April, 2011. And since then, BIAC has come a long way in terms of institutionalizing ADR, in terms of popularizing ADR, in terms of delivering ADR services. So kudos to the leadership team. So today's session chair, BIAC Chairman, Mr. Mahbubur Rahman, moderator, Mr. Rumi Ali, BIAC team, distinguished panelists and participants. Assalamu alaikum, good afternoon. I just wanted to, so I think we have heard from industry leaders, bankers, as well as lawyers. So I was thinking how I can actually add value after they have spoken so well and pretty much covered very, very eloquently all the important issues. So let me bring in three sort of my points under three different aspects. First, COVID and ADR, or commercial justice system. We all know, what havoc COVID is wreaking in the world economy. The global growth is going to be 4.9% negative this year. the Bangladesh's destination, export destination countries are going to have very serious economic depression. United States about 8%, Eurozone 10.2% negative, all negative, UK 10.2% negatives, Japan 5.5% negative. Now, amidst these, the commercial justice system comes into light in terms of investment climate quality, in terms of survival of small and medium enterprises, in terms of smooth operations of international trade in a renewed way. Courts have, around the world have suspended, many hearings, have only resorted to have resorted to only critical business, and then also are encouraging alternative means of contactless, particularly of business. Now, in the midst of that, where ADR comes in, it is no brainer that ADR has been proven as a successful method of delivering justice, which not only helps sustain economic growth, but also helps reduce time cost and numbers of litigations in the court system or the traditional court system. Now, with the courts suspended in majority of the world or resorting to only critical cases, whereby most of the countries do not put the commercial litigation under, how do you go about it? There are new approaches that are happening around the world. For example, Ukraine and Nigeria, they have gone to video conferencing. Bangladesh has tried that to some extent. Belgium has gone to no oral proceedings, only written proceedings and so on. United States, some states in the US are trying something very interesting, court on the wheels. They are actually sending small buses with the judicial officials to the streets to deliver a quick justice system. But it is not perfect, and it is far from being responsive to the increasing number of disputes that are arising as a result of COVID. So COVID-led disruption has led some proceedings to be suspended, and we all expect that the number of new proceedings, the new sort of litigations or disputes are going to increase as a result of many factors, most importantly for the fact that many companies will be going out of business. And as my dear friend Faisal mentioned, many will be filing for insolvency. So in this context, and then in many judicial systems around the world, US, Bangladesh alike, the judicial service dispensing system is just not geared around these electronic courts or contactless proceedings and so on. So that's why the alternate dispute resolution comes into the sort of attention or to the limelight in a sort of with renewed force. Now in Bangladesh, why is RMG and banking particularly important in this particular area? That's my second point. So as we know, like the rest of the global economy, Bangladesh is also going to suffer acutely from an economic perspective, from COVID-led challenges. Bangladesh's very robust growth performance, which averaged around 7% over the last decade, is going to come down to or fall below 2%. One of the biggest hit is going to be our external sector, which includes exports, and exports are dominated by ready-made garments, 84%. We are seeing, suspension of orders. We are seeing changes, potential pressures by the buyers for changes in the contracts, for suppression of prices, and many other changes in the terms and conditions. So they are all going to create an additional burden, not only on the economy, but also on the banking sector. Because as Asif Bhai mentioned, much of the RMG sector's growth has been fueled by the innovations, financial innovations we had from the financial sector, including back-to-back LC, for example. Now, our financial sector steps into the COVID scenario with a lot of baggage anyway, pre-COVID baggage, high NPL. Officially, it's 10%, but now that I'm outside World Bank Group, I can fearlessly say it's not below 25% actually, and the state-owned banks have more than 50%. They had capital adequacy ratio, the banking sector. There is, the average corporate governance can be highly questioned. And then on top of that, we have the interest rate pressures coming from these 9% and 6%, as well as the interest rate suspension. Now, it makes all from all perspectives, it makes sense that the alternate dispute resolution mechanisms are introduced in the international trade system that Bangladesh engages in, because it is almost certain that the international trade system is going to see more and more disputes, whether they sort of go into litigation or can be addressed before it goes into litigation with lesser time cost and more efficiency. That's the question. And we also have to make sure that our banking sector, which is going to be a critical way out of these economic challenges. Unlike 2008, banks are going to be savior this time, whether it's the implementation of stimulus or whether it's going to be medium-term economic recovery support. So we need to make sure the banks also remain as much out of the new trouble as possible, because they already had a lot of trouble. So my third point, what can we do? Barrister Imam touched upon a number of specific policy issues, which I also had mine. So I'm going to add one more to that. BIAC had a big role into that, the mediation rules. I was involved as part of the World Bank group, and one of the, actually not only one of the team members, but the task team leader who worked on BIAC is present. I can see her name on the screen, Major bin Kader, who's now with the Netherlands government. So we worked hard together with BIAC to change the CPC, the Civil Procedure Code. Back in November 2012, we made the amendments. However, it's been 8 years. The mediation rules have not been operational, approved yet. And as a result, the mandatory mediation or the court-referred mediation hasn't been operationalized yet in an institutional form that Barrister Rabbi mentioned. That's one. Second, I think Faisal mentioned exit. Exit is a big barrier in Bangladesh's investment climate improvement and farm level efficiency, as well as long-term planning, which can include exits. So the Bankruptcy Act needs to be modernized. It's a very old regime, and it needs to bring in more insolvency provisions, as well as in line, the Companies Act it was reformed in January. I was involved with the initial sort of bill that we managed to send to the cabinet in November 2018, working with Ministry of Commerce. But unfortunately, what got approved in January was 1/5 of the reforms that we had included. And the ones that got omitted includes the bankruptcy or actually insolvency related provisions as well. So we need to get those two acts modernized. And then finally, BIAC's role. I think BIAC, as I said, has been playing an extremely important role, and so far the only institutional platform providing ADR services. So if there is a way we can bring BIAC more prominently in delivering alternate commercial justice system, for example, a formal or institutional role in the money loan court disputes or the proceedings, which can be diverted through alternate dispute resolution where the seat can be BIAC, I think we can see significant improvements in the way commercial justice can be attained. So let me stop here. Thank you once again to Mr. Rumi Ali and Mr. Mahbubur Rahman for giving me the chance. Thank you.
Thank you, Dr. Riaz. I will now move on to the final speaker of today, and someone who brings a lot of experience, knowledge, and involvement in the ADR process itself. Barrister Ho Meng Hee is a director of alternative dispute resolution at the Financial Industry Disputes Resolution Center of Singapore. He holds an LLM degree from Cambridge and London universities, an advocate and solicitor of Supreme Court of Singapore. Barrister Ho is a state counsel and a deputy public prosecutor at the Attorney General's Chambers in Singapore. He was also in private legal practice where he acted for banks, businesses. He appeared as defense counsel in the Singapore High Court, Court of Appeal. He has been a speaker in international seminars in Jakarta, Dhaka, hosted by Otoritas Jasa Keuangan, Indonesia's financial regulator, and some of our earlier webinars and seminars. Barrister He, the floor is yours. Can we please ask you to give your deliberation? Thank you.
Thank you. Thank you, Mr. Ali, Mr. Azhar of BIAC. Can you all hear me?
Yes, yes.
Right, thank you for kindly inviting me to speak. It is very humbling for me to be here amidst this this distinguished group of speakers here and audience. Now, it was very enlightening and sobering also, listening to the speeches of all the previous speakers. Okay, my heart and prayers go to, I'm sure yours too, our hearts and prayers go to the few million workers in the RMG industry in Bangladesh, what with JC Penney, etc., filing for bankruptcy protection in US, right? So, so COVID-19 has been, okay, my talk will focus mainly on resolving disputes generally. I'll try to have some relevance for the RMG and the banks as I go along, but in the main, you'll be on resolving disputes by ADR means, right? And experience in Singapore. Now, so, yeah, so I agree with BIAC and all the previous speakers who advocate using ADR to resolve disputes arising from COVID-19. So the question is how to promote ADR, right? Of course, many of the speakers here have already talked about that as well. And some of the things I say, they have already covered. Nonetheless, okay, I'll give you my take. So how do we promote ADR? Well, ADR normally arises out of the contracting parties' voluntary participation, as you all know. So the contract in the first place between the buyer and the exporter must clearly express that the parties wish to submit their dispute to ADR. Now, problems can arise, if parties subsequently dispute the validity and effect of their ADR clause, right? So, and now I'm going to focus on mediation for a moment, the mediation aspect of ADR, because it is cost effective, as you know, and it preserves business relationships and also is cheaper and so on. Now, and also the parties themselves play a part in the outcome of the dispute rather than having a third party to come and make a decision or a judgment for you. So basically, the mediation clause must address the dispute to be covered. It must describe the procedure, give a time frame for the mediation to take place, state that there's an obligation to refrain from going to litigation in the courts. So mediation clauses should be clear and certain, right? Complete and comprehensive. You must use words such as the parties shall or must refer to mediation instead of may, because in order for the mediation clause to be binding, it must be expressed in mandatory and unqualified terms, right? Now, another point to note is that you have to be careful how sometimes, especially in complex commercial contracts, people craft or put in multi-tiered dispute resolution clauses, okay? Of course, I'm sure our learned speakers here will know about that as well. These multi-tier dispute resolution clauses incorporate two or more forms of dispute resolution mechanisms, which the contracting parties are required to comply with in resolving their disputes. They typically require parties to participate in any combination of mediation, negotiations, or conciliation processes before the parties resort to litigation or arbitration. Okay. So in short, ADR clauses must be drafted.
I would like to speak. I can give you 2 minutes towards the end.
Okay. Now, although it is commercially attractive, although it is commercially attractive, some businesses are skeptical about the effectiveness of mediation in dispute resolution. Why? Because ensuring compliance with a settlement agreement is often a challenging task. Now, for arbitration, the problem has already been solved by the New York Convention on Recognition and Enforcement of Foreign Arbiter Awards, which some of your speakers have already mentioned earlier on. But what about settlements reached through mediation efforts? Such settlement agreements may be contractually binding, but they are not directly enforceable by an innocent party against a defaulting party in the courts of law. Now, for cross-border commercial disputes, the up-met-up model is one way to enforce mediated settlements. This is a process when, as you know, when mediation is attempted in the course of arbitral proceedings. If the parties are able to settle the dispute through mediation, the mediated settlement may be recorded as a consent award. And then the consent award is generally accepted as an arbitral award and generally enforceable in many countries under the New York Convention. And if they cannot, on the other hand, if they cannot settle to mediation, then they continue with the arbitration proceedings. And then, but if you want to have this up-met-up model, you must have a suitable clause to provide for this in your contracts. And then last year, on 7 August 2019, a UN treaty governing the cross-border enforceability of settlement agreements resulting from international commercial mediation was opened for signature in in Singapore. And this is known as the United Nations Convention on International Settlement Agreements, resulting from mediation, simply known as the Singapore Convention Mediation. Now, this treaty has been signed by 52 states as of 12th of March this year, and it will come into force next month, September. This convention makes it easier for commercial parties in the dispute to seek enforcement of international mediated settlement agreements by applying directly to the courts of countries that have ratified the treaty. Article 3 of the convention states that signatories may, A, in accordance with the respective domestic procedures, enforce an international settlement agreement, or B, where a dispute goes to court, although it has already been mediated successfully, and there's a settlement agreement, then one party may invoke the settlement agreement in its defense. Now, without this Singapore Mediation Convention, a settlement made in one country has no legal force in another, and a party trying to enforce a mediated settlement agreement in another country will have to enforce legal proceedings in that other country, which is troublesome and costly, of course, right? So this Singapore Mediation Convention is the missing third piece, if you like, in the international dispute resolution framework. The other two, of course, as you know, are the Hague Convention on Choice of Law Agreements and the New York Convention on Foreign Arbiter Awards. One more comment I have with regard to RMG before I talk about the banks is that the various government businesses perhaps should unite and band together with the foreign, and then band together in Bangladesh and deal with the foreign buyers, right? Remember, stronger together, right? Then you can negotiate with your foreign buyers better as equals from a position of strength. Now, traditionally, as you know, in contracts, right, people say caveat emptor, let the buyers beware. But amidst COVID-19, it seems that the sellers equally have to be very cautious too nowadays, as some of your speakers have already spoken and talked about just now. So band together and you will be stronger when you deal with the foreign buyers, right? Now, as for the banks in this pandemic, in normal good times, the banks would fear not because they are in a stronger position vis-a-vis the borrowers. Why? Because they have in their hands securities and mortgages when they lend monies. But these are abnormal times. In the light of COVID-19, many countries have recently passed laws, civil as well as criminal, to help people and businesses. Yes, criminal sanctions too. For example, in Singapore, there's a fine of almost USD $4,000 if a landlord in Singapore were to chase his tenant out now, chase him out of his business premises for being unable to pay rent during this COVID-19 pandemic. Okay.
Barrister Heath, I don't have much time. Can you finish within the next 30 seconds?
Okay. So, okay. I also heard one speaker who said that, you know, in Bangladesh, arbitration awards can be challenged in a court of law, right? Well, I would say this, that in Singapore, this will never happen, okay? Because the courts themselves strongly encourage ADR. So somehow, I mean, I'm not an expert, of course, in Bangladesh legal processes, but perhaps you know, there has to be some reforms, and I think one speaker also alluded to just now, some reforms may be needed in the area of bankruptcy and insolvency law, and even perhaps the legal system as such, you know. How Singapore started with advocating ADR is this. The courts themselves play a very active part. They see this as an Asian way of things, you know. We don't argue, litigate. Litigation is the way of, if you like, the Western culture, right? The Asian way is mediation. And so it started as like that kind of a argument, the kind of a line, you know. It's better to mediate. This is the Asian way of resolving disputes. And by and by, it's been 20 over years now. It started in the mid-90s when Singapore courts actively encourage, you know, ADR. Even the courts themselves, before they go for trial, they will have mediation, you know, and if it's mediated successfully, then of course the trial will not take place. And some parties does not want to go for mediation. The judge will say, why not? And there are cost sanctions, you know, so you'll be penalized in terms of legal costs. Okay, so
thank you very much.
Yeah. So the point is that, and then BIAC in Bangladesh, I'm sure is in a very good position to advocate ADR in Bangladesh. Thank
Thank
you,
you.
gentlemen, and I wish you all well in these challenging and difficult times. Yeah.
Thank you, Barrister He. I
Yeah.
think you made some very important points. Stronger together.
Yes, of course, yeah.
And BGMEA, through BGMEA, they have a platform, I suppose, to come together on this issue. Also, you said something about, the courts actually encourage ADR, which is, I think, pivotal and very important. I think if the courts should actually push the cases for ADR and not entertain them straight away. And also, you said another thing, which I also always used to say in the beginning of my presentations about ADR, that ADR is Asian, In our tradition is ADR, because we have something called Shalishi in Bangladesh, which is the traditional way of resolving disputes. And that many, many years where in the villages, the village community got together to, resolve disputes.
Correct. Yes.
I think you're absolutely correct, and we should go back to our heritage. At this point, I'd like to welcome our chairman. I can see he has just joined us, or he has been here, but he wasn't on the screen, at least not on my screen. Sir, thank you. Welcome to this webinar. I think I will request you to speak in a few minutes. But before that, I'd like to give a few minutes, only 2 minutes, to Mr. Sohail Hossain, who wanted to say, he actually mentioned that I just was starting to speak about what I wanted to say. So I remembered that, and I think I'll give him a couple of minutes to say what he missed out. Mr. Sohail Hossain, are you ready? Can you speak for 2 minutes?
I can speak. I can
Please,
speak.
finish in 2 minutes, please.
2 minutes. Thank you, Rumi Ali Bhai. You're absolutely right. I overshot my earlier speech and missed out the important parts. Basically, what I wanted to do was to talk a little bit about the banks, what they're facing now, and then to link it with the RMG sector, the crisis in the RMG sector. I mean, if you look at it, the biggest case for effective ADR is actually the RMG sector and what happened during the coronavirus crisis. The RMG sector, as you said, has exports of almost $32 billion and has 6.8% of the apparel market. It's second only to China. Over the years, the success of the industry has led to a certain level of complacency regarding risk mitigation covenants in the export contracts. This is not only on the side of the RMG factories, but also on the side of the banks. In the past, exports were typically backed by letter of credits from banks, as mentioned, and over time this shifted to contracts only. These contracts have no dispute resolution covenants. The contracts are often preceded by a general MOU, which may actually include force majeure clauses, which are beneficial for the buyers. And a combination of weak bargaining power along with a lack of awareness of risk mitigation steps and negotiation of contracts led to this serious crisis in April and May 2002. Foreign buyers in most cases exercise force majeure clauses to cancel, defer, demand large discounts in view of the worsening coronavirus crisis. I have personally seen contracts where goods have been shipped, goods have been unloaded into ports, raw materials needed to execute a contract purchased, but the contract was unilaterally canceled. I've seen long-term customers, major global brands, ask for discounts anywhere between 20 to 50%. Cancellations in May, March, April accounted for nearly $3 billion. The RMG industry, for most part, had little leverage and for the most had to negotiate discounts or deferments. Litigation was an option, but litigation abroad is neither quick nor cheap. The RMG factories had bank loans, overheads to contend with, although the stimulus package helped to mitigate the risk partially. Furthermore, the adversarial nature of litigation meant that future relationships could be at risk. The
Syed, I
inclusion.
think you have overshot the time again.
Okay.
I have to. I think, but you have made your point.
Just one line, which is the inclusion of ADR in future contracts supported by the government of Bangladesh and the banks, I think will be critical going forward. Thank you.
May I have 1 minute to respond to what Sohail said?
Asif, is that Asif?
Yes, that's me.
Okay, 1 minute. Go ahead.
Okay. First, I would like to say Assalamu alaikum and a good afternoon to the chairman of BIAC, Mr. Mahbub Rahman. Chacha, Assalamu alaikum.
Assalamu wa rahmatullahi wa barakatuh.
What Sohail said, it is very interesting because in my opening remarks, I had said that it is all about the bargaining capacity of us as Bangladeshi suppliers. It is very difficult for us to go to the buyer and say, you put that in the clause, the ADR clause in the letter of credit or in case of contract. But last part of what Sohail said, I don't know whether it will be workable or not, but we certainly need to have the government backing us in this, and perhaps the central bank.
Okay.
And then if that is the case, that if they want to, have a transaction done through a contract or a letter of credit with a Bangladeshi RMG factory, if it's bound by law, then that's a different issue altogether. But that
I think that's a point which was made earlier in one of our earlier webinars also.
Right.
That if it can be done through from the state level and with the central bank support and the Ministry of Commerce support, it can be done. But yeah, absolutely. I think I'll take that on. I think we've come to the end of today's webinar, and before I, invite our chairman, Mr. Mahbub Rahman, to say a few words to us, I'll just put it together. The whole issue of this this webinar, came to my mind when I saw not only this webinar, I've been working on this with BIAC and trying to work with it with BGMEA. This post opinion column of Daily Star, where I think one of the garment industry owners wrote, is this what our contracts are worth, or something on those lines. He was frustrated that the buyers have walked away without any consequences from the contracts. So that set my mind working, why has this happened? And what I found when I actually looked deeper into this is that most of the contracts that are taken signed between the buyer and the seller in the RMG sector don't have an ADR clause at all. And the jurisdiction of all contracts, irrespective of the amount, is with the buyer's country. And so, you start on the back foot in this. And one of the issues which was mentioned, I think, by Faisal Samad, is the imbalance. I think you also mentioned it, Asif, the imbalance between the two parties. But my view is that this big multinationals, and I've had an opportunity to interact with them when I was a member of the board of the American, ABWS. That after the Rana Plaza, they had two. One was the Accord, and the other was ABWS, where I sat in the board. And there I saw that one of the things they're always concerned about is public opinion. What will the people hear? What will they say? So their view is that if there are issues, let us deal with it outside the ambit of people knowing about it confidentially between you and me on bilateral basis. So if that is the case, I think they wouldn't really be against not arbitration, mediation, because mediation is their preferred way of dealing with these problems. It is confidential, it is between two parties, and it doesn't become subject of discussion by anybody else except the two parties. Of course, you can move on to arbitration, but as I've experienced in a visit to a global arbitration ADR summit in Beijing a couple of years back, where they actually said in the more advanced countries, mediations are now outstripping arbitrations. There are more mediations happening than arbitration. And as Barrister he said, just a few minutes back, that they are now taking on mediation strongly. So I think if you took that route of mediations, rather than going for legal case, they wouldn't really be. But important thing is in mediation, it should have that structure. I think Barrister Rabbi mentioned that it should be under a framework. So have it under a framework. And again, I would quite blatantly support BIAC mediation law rules we have, which can be a framework. If you do not accept that it should be BIAC, say institutional mediation, and we can come in over here to help you. And definitely BIAC is ready to help the garment industry. As I mentioned, they are the most important industry. This country owes a lot to this in the RMG industry for its growth, and not only growth, also in empowerment of women, because no other industry has supported women's empowerment the way this industry has. So there are a lot of pluses. And I would like to reassure Mr. Samad that this is not about trying to find faults with the industry. We are here to help you. So you've got to think about us as friends, not an adversary. We are not here to pick points which are causing issues for you. We want to support you in trying to make the industry more robust on a global basis. And if we can do anything to help, definitely we will be the first one to raise our hand. And that is exactly why we took the initiative and on our own actually went to you and said, if we can be of any support to you, we are there. Particularly since you have an arbitration center, we'd like to help you to beef that up, make it more, or work with us so that we can make it a more effective institution in these situations like this. And the banks, I think, can come in over here because they should be supporting BIAC to do this, because if we support them, they mitigate their risk in a way, because they have no mitigation for their risk when a contract goes bad. Through this, they can actually help to mitigate the risk of a failed contract. And this will happen again. I think the industry should be ready so that they do not face this situation the next time there is some other issue, maybe not a pandemic, some other issue, whether individually or as an industry face this issue in a more robust way, and that protects everyone. So with those words, I'd like to finish my here. I would like to thank all of you. I think it was a fantastic group. I've learned a lot myself. BIAC has learned a lot, and BIAC certainly will be taking these recommendations and trying to work on them. So individually, all of you, thank you very much for coming here and accepting our invitation. And now I'd like to hand over to our chairman. I think if I try to introduce our chairman, I'll be disrespectful of him in a way, because our chairman, the founding chairman, to be more precise, is someone who is known to the business world, to everyone for a long time. And I can just say that he has been the president of FBCCI, president of DCCI, president of so many chambers, and received awards all over the world, not only here. He has received the Friend of Indonesia award from the president of Indonesia. Is one of the awards I will mention over here. So we at BIAC consider it a privilege to have Mr. Mahabub Rahman as our chairman. He is the visionary who actually envisioned BIAC long ago in 2004 and applied for a license. And he got Dhaka Chamber, the Metropolitan Chamber, and the ICC, the chamber he is the president of. So we share the presidentship, our chairman, with the ICC. We'd like to keep him to ourselves, but he has given time to them also. So he actually set this up, and actually we have been trying to make it successful, and we need your support to make it successful. With these words, I'd like to invite our chairman, Mr. Mahabub Rahman, to say a few words to us. Thank you very much, everyone.
Thank you, Rumi. And I would like to endorse your viewpoints on the issue of BGMEA coming forward to help you. And in this case, the Faisal and Asif, the young leaders of the BGMEA in these days, can be very useful in bringing about a change in the whatever it is there before. But the arbitration that is being, or mediation that is being conducted by BGMEA, you can say somewhat in-house. And therefore, it is because BGME being a party by themselves, it is sometimes difficult for some other parties, but within themselves, within their members, such arbitration or mediation is somewhat possible, but not definitely with their bias, because BGME becomes a party to that. But nevertheless, I would like to request their support in bringing about a change in the total landscape and scenario of Bangladesh legal system, and particularly the commercial arbitration, because the business do need it very direly, and it is very important that we should go to resolve cases outside the court. And as the court cannot deliver, for reason behind you all know. From that point of view, I would consider that such your interaction, your from time to time, now that in the COVID situation, you are doing it webinar. As far as I'm concerned, I'm a total illiterate person as far as IT is concerned. And my son helps me that I'm just talking. I do not know anything. What about he put everything together? So therefore, you are doing it through this, what is called platform, virtual platform. This very, very good. But maybe, I do not know when this the COVID will go away and how the total scenario in the business as such will be in the coming days. But we are becoming tech savvy in the days to come, no doubt about it. Just to give you some formal thing, the banking sector is the key player of the economic activities of the country. As a developing country, we need to be more watchful in terms of planning to get rid out of this impact of COVID-19 outbreak. We are already suffering heavily due to non-performing loans, and unfortunately, the outbreak of the pandemic may increase the levels of NPLs in the coming days. The NPLs can be split up in two phases: pre-COVID NPLs and post-COVID NPLs, in view to look at and understand the fact more judiciously. Therefore, it is pivotal to focus on the early bailout plans for probable collapse of large loans. This is very, very important from that point of view, because banks are already overburdened, not overburdened. In certain measures, you can say many of the banks should declare them bankrupt. But in Bangladesh, the situation is somewhat different, despite the fact that many of these non-performing assets are not delivering anything, but they are continuing to be the asset of the company. So from that point of view, we should be very, very careful, extremely. In the circumstances, we would suggest that inclusion of an alternative dispute resolution clause, which Rumi has already mentioned, in commercial contracts between parties in the RMG sector, can safeguard their rights and liabilities in the wake of the COVID-19, given the fact that our courts are already overburdened with case dockets, and resorting to ADR mechanism will save time and money of the parties. And we are confident that such ADR clause will save time and money of the parties. We are confident that such ADR clause will also safeguard risk management protocols of the banks and protect their rights as well. Our trust will be to dispute resolution through ADR mechanism in all upcoming cases. To repeat again that what Asif and Faisal has mentioned, that the parties, the buyers, very often than not, would not like to take the terms of the seller. Here, this is always, it is the buyer's privilege. And therefore, they are not agreeing to the terms that is being given by the seller. And not only that, the such dispute resolution, if there be any, should be in the buyer's country. That is something, a different situation always. But it can be always international dispute resolution. Such resolution can be made in Singapore. It can be done in Tokyo. It can be done in London, anywhere, but under our rules. And our rules are always incompatible with the Incoterms, with the what is called UN UNCITRAL, AAA, American Arbitration Association, and because ours are not made by us, it is incompatible with all of those international arbitration center are quite in concert with this. From that point of view, I would consider that you will continue to pressurize your buyers to agree to that, because we have come a long way. This is already from, if I consider from 40 years of our garment industry in this country, and we should try to play some of our roles in order to bring about a change in this situation. But anyway, you have your limitation. You can always understand so, but we shall have to try and strive to achieve something that which is always beneficial and going to support our system as well. Thank you very much indeed. And I would like to thank every participant from home and abroad for in this webinar. And please extend your help and support to the BIAC, because it is going to survive only with your support. Thank you so much.
Thank you very much, Mr. Chairman. Thank you, distinguished participants, and I thank our chairman for saying a few words, energizing us, and I'm grateful to all the speakers for their useful deliberations. I also thank our CEO, Mr. Mohammad Rumi Ali, for conducting the session, and here we close the session. Looking forward to your cooperation in our future events. Thank you so much.